Welcome everyone. We're going to give it a few more minutes. I see people still joining. Glad you could join us today to talk about the move from a subcontractor to a prime contractor. So stand by for a few more minutes and then we will start the presentation. All right, everyone. My Apple phone is telling me that it is 12 o'clock, so we want to be mindful of everyone's time. We've got a lot of information to cover, so we're going to go ahead and get started. We're glad you could join us for part 2 of our guest speaker series, where we talk about making the move from a subcontractor to a prime contractor with the federal government. We have gotten this webinar approved for CPE. So if you're interested in getting that hour CPE credit, if you wouldn't mind, send Cami Maynard, who is helping us behind the camera, if you will. She's helping us with the show. If you can just send her a chat. Everyone should be muted except for our panelists. But if you do have a question, send it via chat, and we will try to answer it as time permits and as we get a break during the webinar. My name is Brandon Smith. If you joined us for our webinar a couple of weeks ago, you'll see that I still haven't got my headshot updated, but you are in the right place and you have the right people that you signed up for as part of the webinar. I'm a partner at England, Reichman Armstrong. We have offices in Huntsville, Alabama, and Pensacola, Florida, and I, along with Michelle Jenkins, head our government contracting group. We both primarily work in the solutions department, which is what we call our consulting group. Our firm also has an audit department where we work with clients for audited financial statements, 401k audits, other agreed upon procedures. And of course, being a CPA firm, we have a tax department. And they're, in addition to preparing tax returns, doing the multi-state returns, also assist with various credits and other taxation issues and tax planning. So I want to introduce from our firm, Michelle Jenkins. Michelle is a manager and the department head of our solutions consulting group. Michelle, you want to tell everybody a little bit about yourself?
Yeah, sure. So like Brandon said, we both work in the government contracting group, work with consulting. I've been in government contracting for about 9 years now here at the firm, and focusing on all things kind of related to that, both from the start of the business to kind of towards the end. So lots of fun and exciting things. And we are looking forward to today's training. So thanks for having me.
All right, thanks, Michelle. And we are certainly excited to have Dale Gipson from our friends over at Maynard Cooper Gale. I can't tell you how many times we've reached out to Maynard and specifically their government contracting group to help us with mutual clients that as issues arise. And they've always been a great resource for our firm. And we're happy to have Dale on today. Dale, you want to introduce yourself?
Yeah, thanks, Brandon. Dale Gipson, as Brandon was saying, I'm a shareholder at Maynard Cooper and Gale. We're a full-service law firm based in Alabama, but we've got 11 offices coast to coast. I practice in our government solutions group, which is based here in Huntsville, and then we also have some practitioners in Washington, D.C. We cover the gamut of government contracting issues from bid protest, contract negotiation, government contractor M&A. You name it, we touch it.
All right, thanks, Dale. We certainly appreciate you taking your time out today to help us out. So let's kind of get started with the presentation here and kind of get in the meat of this. Before we get too far into it, let's just make sure we're all on the same page. I know, acronyms and different sayings get thrown around the government contracting world. We were laughing earlier when we were going through our run through that Microsoft and Webster's Dictionary don't feel that deobligate and unallowable are words, but anyone in government contracting knows that we use those quite frequently. So just to make sure that we are defining things in the context of today, when we're talking about a prime, we are talking about a company that has a contract directly with the federal government, and that's the entity that's ultimately responsible for performing all the work on that contract, making sure everything's done. Now, you can be a government contractor and not have a direct contract with the federal government through subcontracting through another company. So there may be a company in town that has a contract with the federal government, and maybe they don't have a particular expertise, or maybe they've teamed up for a different reason and they elect to subcontract out some of that work with another company. And there are some contracts that actually have requirements for a particular small business or another type of set-aside business to perform on the contracts. So we're going to jump right in, kind of just make sure everyone joined that we thought would, make sure everybody's awake out there, and start with our poll question number 1. Cammie, if you wouldn't mind launching that, and that's just kind of get a feel for our audience to know, are you currently doing any prime contracts with the government?
And we'll just give everybody a couple of seconds to take a look at that poll question and give us a quick answer, and then I'll close the poll. All right, looks like everybody's voted, so I'm going to go ahead and close that down.
All right, Cammie, can you tell us the results? They don't show up on presenting.
It looks like we had 29% said yes, and about 71% said no.
So, the majority of our audience then, it sounds like, is still in that subcontractor world. That's very common what we see, particularly with the smaller businesses where they're getting started and the majority of their work is coming from a relationship with a larger prime. And part of that natural business cycle is moving on to become that prime contractor. So Michelle, I know clients always ask me, and I bet you get the question too, when they want to know, you know, I've been doing subcontracts, things are going well. Michelle, do you think I'm ready to take that next step? What do you tell clients when they ask you that?
Yeah, that's a great question, but also a little bit of a difficult question because it can vary, you know, client by client. The few things that I usually tell people to kind of look at your entity structure and consider when you're looking at prime is, one, what is your infrastructure like within? Do you have a mature infrastructure ready and set up where you can handle really understanding the contract side and the accounting side, what it's like to manage the subs and manage the contract? And so those are key things that you really want to make sure you have a good foundation in. You want to make sure that you have some knowledgeable relationships, whether that's internal or external. And really what I'm talking about there is you have a good attorney or a good accountant, whether it's in-house or a consultant that you're using that really understands all of the rules, regulations, and what it means so that you've got everything in place from the very beginning to really make sure that you're in line, you know what you're agreeing to, and you kind of know at the very front end how you're going to run that prime contract. So it's pretty important to have that. And then I think it's also really important, and we're going to talk about this as we go through the presentation today, is really understanding what it means and what is written in the contract that you are going after for a prime, what the rules are. And so that kind of all plays in together, but really having that support and that infrastructure within your entity, as you see when we talk through what all is involved, there's a lot to kind of know and be aware of. And so I think another few things to think about is some of the big changes moving into that prime role. You know, one big change is you're going to be the person managing that relationship with the government. You're going to be the person or the company managing that relationship with the subcontractor and also managing the work. And so there's just a lot more pieces to that part of it, and just making sure that you've got all the players you need to handle that. And then another thing kind of coming into it is, you know, as we'll talk about later, again, cash flow is going to be a whole different kind of concept as well, just making sure that you understand and are able to financially perform that prime contract and pay your, not only your company, but also with any subcontractors you have working with you and those sorts of items. Just things to consider as you're looking through it. And like I said, each one differs contract to contract based on what you're looking at. I'm sure Dale has a few more things we could probably add to that from a legal side.
Yeah. Dale, what did you, when a client calls you, I know you guys are working with them every step of the way and advising them, but when a client calls you and they say, hey, we need help with a subcontract agreement, we're ready to be a prime, what's your first thought and what are you telling them before they make that leap?
Yeah, so I think, you know, everything that Michelle said was spot on. The other thing I would add to that is from a practical consideration is addressing past performance and how you're going to get that win. I mean, the FAR generally requires that the government evaluate past performance, and even though they're not permitted to ding a contractor for a lack of past performance, it's still a factor in the trade-off. And one of the things that the government looks at is, do you have performance managing subcontractors, which is obviously a concern for a contractor that is going to be doing their first prime. And so one way of dealing with that is that the FAR permits a contractor to count the past performance of their key personnel. So if you're able to bring on a good, experienced program manager for a procurement, that's a good way to bridge that gap from going from a subcontractor or a prime contractor to utilize the past performance of an employee when you don't have enterprise-wide past performance. So that's one of the things that I look at is, you know, are you in a position to win after you've gotten the infrastructure and everything else that you need in place? You know, do you have the discriminators you need in a proposal to win award?
That's great, because I guess that's a great point, Dale. That's what it ultimately boils down to, is winning more work, right? And so, that's got to be part of your execution strategy as you're trying to formulate your proposal strategy. Am I going to be able to win it? Because we can talk about being a prime, but until we actually have that strategy to win an award as a prime, a lot of it's just that talk. So I think that's great advice you're giving your clients there. All right, we've got poll question number 2, and this one, we're going to talk about it a little bit more. Cami, if you can go ahead and launch it. And we're kind of gauging the audience here about teaming agreements, and then we're not going to do the results yet. Dale is going to talk a little bit more about them before he gives us the right answer to the poll. So Cami, if you can just let me know when the results are in, and then you'll hold the results so till the next slide, then we can talk about them.
Okay, I'll go ahead and give everybody a couple of seconds to take advantage of this poll question, please. And then I'll close it in just a moment. All right, we're going to close the poll down.
All right, thanks, Cami. So when companies start working together, we hear a lot of terms get thrown around. Am I going to be a subcontractor to this company? Are we going to start a joint venture, or have a JV that we're working? And teaming agreements factor into that a pretty good bit. But Dale, kind of give us a little rundown of what those teaming agreements mean and how they may be applicable when I'm a prime looking to form those relationships with some subcontractors.
So I think of a teaming agreement as just sort of setting the stage and establishing the relationships that the prime contractor is going to use to move forward with performance. So if there are certain aspects of a procurement that a contractor wants to go after, they don't feel like they can handle themselves, one way to address that is to use subcontractors. And a teaming agreement is a way to establish a legal relationship prior to entering into a subcontract agreement, so that the parties can collaborate on a proposal. And there are a few different things that I think are important in considering how a teaming agreement is structured and negotiated. One is whether it would be exclusive or non-exclusive. The vast majority that we see are exclusive, and typically, if you're going to be a prime contractor, you would want exclusivity with your subs. You don't want the same subs to be offering the same services to a competitor on the same procurement. Similarly, if you're on the subcontracting side, you prefer the alternative, to be able to be on multiple teams, perhaps. Other issues that are important are defining work share. It can be really helpful for contract negotiation later when you're after award and you're working to negotiate a subcontract. If the parties have a good understanding and the same expectations about what work share is going to be. That way there aren't disputes later that can interfere with contract startup and performance. Other issues that we see come up a lot are intellectual property issues. Probably most of our participants are familiar with data rights that the government receives to technical data and also to software in the performance of government contracts. I think it's a good idea to set expectations up front in a teaming agreement about what intellectual property rights, if any, a subcontractor is going to need to contribute to the performance of that contract. And then, finally, qualifications. What I talked about earlier, past performance would be an example. What past performance is the prime lacking that it needs to bridge with a subcontractor? That's a great way to think about subcontractors. And then any other qualifications like top secret security clearance, ISO 9001 certifications, that sort of thing. All those sorts of things that are required for award should be addressed in the teaming agreement.
So Dale, I guess what we typically see is one of our clients will identify an opportunity they'll start reaching out to potential teaming partners as they formulate their response. When's the right time to call you guys? What stage during that process should they reach out to to the attorney and call over at Maynard to say, hey, we're ready for the teaming agreement? Is it kind of before they start talking and getting into specifics, or should they already have those, kind of somewhat worked out? Or when's the best time to reach out to you guys on that?
Yeah, I think a teaming agreement is something that you want to have basically in a form that you can revise as needed through opportunities. So I think it's a good idea to have counsel put together a document that you can use over and over again, but as modified as needed for particular procurements. But I don't think it's something you necessarily want to wait until you're ready to have one signed, because sometimes, that putting anything in a rush is not necessarily the best idea. But when possible, if you can have those conversations early, that way there can be a more sophisticated conversation about what type of work you're going to be going after. Do you anticipate the contracts to be, firm fixed price or cost? Is it logistics? Is it software? Is it engineering services? But because all of those elements have an effect on what a good government contracts attorney would put in an agreement. It's not just something, you would just take off the shelf.
All right. So I guess with that said, Cammie, tell us what our poll results are, and then we'll let Dale kind of give away the answer there.
So it looks like we have 60% that said yes, and we had 40% that said no.
Well, I'm surprised by the poll results. I thought most people would say that they're not enforceable. In my experience, people generally think that they are not, and therefore don't treat them very seriously, because they tend to think of them as sort of throwaway documents. The answer to the question is really that it depends. They are typically enforceable to the degree that if the parties agree that they're going to negotiate to get to a subcontract, that obligation is typically enforceable. You have an obligation to go and negotiate in good faith, but they usually don't have enough terms in them in terms of specific work share, price, and things like that to be enforceable to cause a court to grant somebody damages for not performing the work. That can obviously be changed in a particular subcontract. If a subcontract said, this subcontractor, or if a teaming agreement said this subcontractor is going to perform 40% of the work and they're going to get, fully burdened labor rates at X dollars, that would be enforceable. But short of that, it's probably just the obligation to negotiate that is enforceable.
All right. Thank you for that great information, Dale. All right. So Dale's mentioned a couple of times, I think Michelle has as well, we've talked about work share. So we've got a poll question kind of discussing work share and understanding it. So Cammie, if you don't mind, go ahead and launching that question.
Okay, I've launched the third poll question. If you guys will please take a moment to read and answer. All right, and here in a moment, we'll go ahead and close that poll down. All right.
Cammie, you want to go ahead and give us the results of that one?
Looks like 100% said no.
Well, that's not uncommon. It's the work share is can be complicated to define and calculate. Part of the reason is because different federal agencies define how they calculate it differently. And so a lot of the times it's going to depend on who your contract is with, on how it's defined. General rule of thumb I've found is if I can take my subcontractors, take it as a percentage of the whole contract before fee, that's a pretty good breakdown and is pretty applicable across most federal agencies. but you should probably check with either your legal counsel or your CPA to make sure if you're worried about them. You know, a lot of times the work share is a big driver on these jobs and these contracts and these teaming agreements being executed as both companies see an upside and both want, you know, the share that was agreed upon. And it can be an inexact science on certain contracts where it's not a predefined set of hours or set of labor or something like that, where, you know, you're kind of doing more IDIQ type work. So working out those calculations can be very important though. So, you know, as we kind of think about work share, you know, there are some limits on what I'm able to subcontract out. Michelle, you work with a lot of tribal organizations. A lot of times during those contracts, there can be work share with other tribes, other entities that are providing past performance, or at times the tribal organization can be a subcontractor if, you know, some of those set-asides were required, as we mentioned in a previous slide. What do you tell clients when they're trying to understand those limits on subcontracting and understand, you know, how much can I really outsource, so to speak, or subcontract out of this work?
Yeah, that's always a good question and something that we'll usually talk through. I think the biggest thing, first off, is kind of knowing that contract, what's written in there, and really looking at it contract by contract and understanding what the limitations mean. So a lot of times they may come away from a meeting with someone like, you know, Dale over at Maynard, and they may say, hey, for instance, I can't have a third tier sub, which means I'm a prime and they can use a sub, but they've come to me and they've asked, the subcontractor has asked if they can use temp labor. Does that count as a third tier sub, or is that, you know, not in that realm? And so there's a lot of areas where you kind of have to start looking one by one in those circumstances and really look at what you're asking and how it applies into the rules, which kind of circles back around to really having people in your court that really know the regulations and what those items mean. So that's a big thing, I think, really to kind of understand is with these limitations and how you guys plan on operating and what your plan is for performance and how that applies into the contract.
So Michelle, you hinted on subcontractors versus consultants. And, you know, I know from an accounting perspective, a lot of times that question comes up when we have a client that has a value add rate structure. So they have a sub and material handling pool, and they ask the question to us, you know, a lot of times, do my consultants go in that pool? A lot of times we won't put them in there because usually the thought on the subcontract material handling pool is I'm dealing with a company that has, you know, an infrastructure in place with an accounting department and an HR department and all these other things. And so they should require less of my resources except for maybe my procurement person. Whereas a consultant, a lot of times we think of it as a one-man shop, a 1099, if you will, the one person who they may need a little more hand-holding, a little more support from the organization. I mean, that's pretty fair for how we typically break those out. Would you agree?
Yeah, no, I think that's spot on. And so you'll see that a good bit too, I think, as you go through a lot of the, I guess, proposals, or when you're walking through, even all the way through to the incurred cost submission, is making sure that's broken out. So when you are capturing if you do have value added, you are capturing your material handling, they are not included. Even if you don't have material handling, that you are capturing them separately from your true subcontractors is important.
So Dale, that's how we look at it a lot of times from the accounting perspective. I guess legally speaking, when I'm drafting agreements and I'm putting agreements in place, is there any difference from a legal standpoint between a subcontractor and a consultant?
And we'll talk about FAR flow downs, but from a flow down perspective, there wouldn't generally be a difference. You would still be required to flow down the same provisions into the consulting agreement that you would into you know, a subcontract agreement. The only exception to that I could think of would be if you had someone that you had, categorized as a 1099, but they're really acting, as your personnel for this particular procurement. You're making a distinction between them being, just providing, service under that one agreement versus being, sort of a separate one-man consulting firm. But most of the time, I would expect you would need to slow down those requirements. Now, they may ultimately not be all that applicable to a company that has, one person within it, because many of those requirements, have thresholds that are based on number of employees and things like that. And so while there might be a flow down requirement, there wouldn't be any real impact on that person.
Okay. And, if anyone does need to see more detail on this, 13 CFR 125.6 has your full limitations on subcontracting defined there. And of course, you can always reach out to your counsel or your CPA firm to help you guide through that. So, as we start thinking about, there are requirements for certain work share or limited amounts that we can subcontract out. At some point, our government customer may want to double check us and make sure we're doing those things. And so, Dale, do you have clients come to you that are worried about the plan, their subcontracting plan, or trying to make sure they're compliant before one of these compliance reviews takes place?
Yeah. So when a contractor is required to have a subcontracting plan, which I think we're going to talk about later, there are specific elements in that plan that the contractor is required to meet, and the standard that is employed is that they're making good faith efforts, and the both the FAR and the SBA regulations put forth some ideas about what would constitute good faith efforts. And so we often help clients when they have their specific subcontracting plan put in place compliance policies that allow them to show that they're making a good faith effort, or if they are in the process of an audit, we can help them demonstrate compliance, or to the extent we find elements of non-compliance, help them just get a plan moving forward so that they can show the government when you come back, because typically if there's a compliance review with a deficiency, the government's going to come back and evaluate that a second time, sometime within 6 to 18 months from the initial review. That way they can move forward and get a passing score following that initial compliance review. That's sort of the basics of what we do in compliance reviews.
So let me ask a question then. So aside from the government customer, let's say I'm a prime contractor and one of my subcontractors, they think that they're not getting their fair work share, have questions about it. What am I obligated to share with them as far as the work share? Because, there could be other subcontractors involved in this, or could be proprietary information. What am I generally required, or is it dependent on, how that subcontract agreement is drafted?
Yeah, so there's no general requirement for information sharing with a subcontractor, unless, like you said, that there was a provision in the subcontract agreement that would provide for it. That's fairly unusual. What I will say, though, is a prime contractor is not permitted to prohibit a subcontractor from having discussions with the contracting officer about the subcontracting plan and whether the subcontractor is being treated fairly under the subcontract agreement. And so, just as a matter of good contract management and relationship management, I think it's a good idea to try to be as transparent as possible without giving up, proprietary information, to allow a good relationship with the subcontractor, and also to prevent that subcontractor from calling up your KO and saying, my prime is not treating me fairly. They're not providing the work share that they were supposed to provide. And, a contracting officer doesn't want to get that phone call. They've got enough on their plate. The last thing they want to do is feel like they're having to help manage your relationship with your subcontractor. So the extent that you can avoid that, that's the best thing that you can do. And typically these work share requirements, and again, we'll talk about the specifics of these plans in a moment, but they're typically set forth as goals. And when you are providing work share to a subcontractor, it's stated in terms of a good faith effort to provide that work share. It's not, a fixed requirement set in stone that can't be changed. And as long as the contractor, the prime contractor, has good reasons for what they're doing in terms of work share across their subcontracts, that's generally going to be upheld and okay. So I think what's important is just communicating that in an effective way with your subs.
So we got a question. I think you answered it, but the question we got in chat was, what about working with bigs? And the proposal clearly states 38% will be performed by small businesses. How is that enforceable and to what extent? So if I'm hearing you correctly, I can go to this large prime contractor. They could potentially stonewall me and say, we're not sharing that information. I have the ability to go to the contracting officer, and ask them if the plan is being adhered to. It's probably not a good look for anybody. It sounds like the large prime doesn't want that, and it may damage your relationship with them. But I think we've answered the question. Follow up in chat if we didn't clarify exactly what you meant on that. But I think Dale had done a pretty good job of answering that question already. All right. With any of these things, and we're not going to go through all these FARs except to kind of try to give you guys a pointing spot to go and look at some of these. But Michelle, are any of these, CFRs or FARs, are any of these ones that you steer people to more often than others, or that you go look at when you're trying to answer a question for a client?
Yeah. So these are actually probably the most commonly used, the ones that we've put here. There are a good bit more that you can reference. And if you go out to the SBA.gov website, there's a good bit of information out there that has additional subcontracting rules and regulations. But these are probably the most used ones to go through. If you're, get familiar with them, understand what they mean, and just kind of know when these do come up. The content behind it is important to have that in your back pocket.
All right. So, as Michelle mentioned, there's some kind of a little bit of a cheat sheet for you here on a few of these. But, if you're worried about a size status, where do you go? Certain SBA subsections, where do you go for that? Maybe a good resource for the question that was asked, subcontracting assistance for small businesses. What is a small business subcontracting program? So have a few references there. We have a few more on the next page, but we've hinted on subcontracting plans a couple of times. Dale, when people are looking for this plan to come out, it's typically driven by the contract when that's required, right?
Yeah. So if a prime contract is expected to exceed $750,000 in value, then the prime contractor, if the prime contractor is not itself a small business, is required to put in place a small business subcontracting plan. And that plan, kind of like the question that the participant asked earlier alluded to, requires that prime contractor state in specific terms in the plan what percentage of subcontracting dollars are going to be given to small businesses, hub-zone businesses, 8A businesses, WOSB, service disabled, veteran-owned small businesses. All those are required to be set out in percentages relating to total dollars subcontracted. And the plan is also required to make that prime contractor agree to expend good faith effort to meet those subcontracting goals. And so if the contractor is not able to demonstrate that they are meeting those good faith efforts by, for example, breaking the work under the prime contract into manageable units that a smaller business could take on, providing small businesses with the information that they need to properly submit, a bid or respond to a request for proposal, any of those sorts of things. Basically, any sort of action that the prime could take to demonstrate that they are actually attempting to, meet these goals. So those are all things that could go into good faith. But if they don't, that can result in unfavorable past performance. It can result potentially in contract default and termination. Unlikely, but it's possible. And then it can also just, have your subcontractors go and talk to your contracting officer and poison that relationship if you're not managing that correctly. The one other thing I would say is that if a prime contractor names a particular sub by name in the proposal, they are required to use that sub to the extent named, unless they have a good reason for not doing so. So they were unable, for example, to negotiate a reasonable price. But those are all things that come into the subcontracting plan. Excuse me.
So Dale, do you ever see the subcontracting plan as a reason for, it sounds like it can get it thrown out in proposal if you're not adhering to it, or at least give you unfavorable ratings. Are they ever grounds for a bid protest? Do any of them ever go down that route for having an inadequate plan, or maybe, there's questions. One of the notes here is about the small business must self-certify that they're small. Is that ever grounds for a protest?
Yeah, the subcontracting plan itself is not usually protest grounds unless it is specifically called out as an evaluation factor in the solicitation. So if in section M of the solicitation, the small business subcontracting plan is a specifically evaluated requirement, then failure to provide an adequate plan can be protest grounds. But other than that, it's an issue of responsibility and contract administration, and certainly failure to follow a plan, once performance has started, that's not a protestable issue. That would be solely between the government and the prime contractor, although, as we talked about, the subcontractor does have the ability to go to the prime or go to the contracting officer and complain if they believe that plan is not being followed.
All right. Thank you for that. Michelle, we've got a few more FAR clauses here. Anything to add about any of those additional reference points that we have on there?
No, I think we've got some items. If you'll go to the next slide, I was gonna touch on just the other FAR clause, kind of looking at that. And I think Dale will give some more background on some of this required versus desired FARs to flow down into the sub.
Yeah, to make sure everyone understands what we're talking about on that, as you become a prime, you are going to have specific FAR clauses in your contract with the federal government. Now, when you subcontract part of this work to another company, that is it going to be a subcontract as part of your team agreement or subcontract plan, some of these FAR clauses are going to have to be flowed down or included in that subcontract agreement. You're going to have requirements to do that. Other ones, maybe not required, but a good idea. Dale, can you help us figure out which ones are those required and which ones we may want and why we would want them?
Sure. So the FAR in Part 52.2, which they pretty much all start off that way, Part 52.216-7, or 203-13. Those are all the contract clauses that are prescribed in the FAR that the government includes in its contracts with its prime contractors. And each of those clauses will either have a provision in it that says you are required as a prime contractor to include this clause in your subcontracts, or it will be silent on that issue. And if it doesn't say anything on that issue, then it's not required. So we look to the clause itself to determine, do we have to incorporate this clause into a subcontract? And if so, they need to be included. And the concern is that if you fail to include a clause and the government's ultimately injured by that, there could be, a breach of contract action that by the government against the prime for failure to bind that subcontractor to these clauses. And some of the examples that we have here are the certified price and cost data, 203-13, that's your contractor code of conduct and business ethics, which is the provision that requires that you have a policy in place and to report any violations of certain provisions of law if you have a contract with a value of $5.5 million or greater. 252-204-7012 is the DFAR cybersecurity clause, which requires that contractors with this clause in their contract comply with the NIST 800-171 cybersecurity standards. These are all required to be flowed down into a subcontract. Your Part 22 clauses, which are your employment clauses, like the equal opportunity clause, those are generally required. Other clauses, though, are silent on that issue, and there would be no requirement for a prime to put those into their subcontract. But if they fail to do so, they could find themselves in a contractual position that could cause a problem. So for example, you have a prime contract and you have a subcontractor, but you haven't included a termination for convenience clause. If the government then terminates your contract for convenience, you don't have a contractual right necessarily, and unless you've included it, to terminate that subcontractor for convenience. So you could still be liable to pay that subcontractor their profit, even though you're not going to get paid from the government. And so clauses like that are imperative from a risk perspective of incorporating, even though the FAR doesn't require that they be incorporated. And the reason it doesn't require it is because the government's not affected. But the contractor would be well served to include that. The same could be said for stop work clauses. A lot of the Part 27 clauses, which deal with intellectual property, patent assignment, rights and technical data, rights and software. If the prime contractor is required to deliver those things to the government, they also need to either require that the subcontractor deliver that intellectual property either to the prime contractor or directly to the government, either way. But those are all considerations when putting together a good subcontract agreement. And that's also why, it's generally not just a good idea to, just grab a form, because all these things need to be considered in reference to your particular contract.
So to your point on that, once it's in there and I sign the contract, I got to adhere to it, whether, they were required to flow it down or not. So it sounds like, we've got a lot of people still, a lot of the participants on here are still fully subcontract. Sounds like it may be a good idea to have you, for them to reach out to their counsel and maybe make sure they understand all of these clauses that they are contractually agreeing to adhere to. Michelle, are there any FAR clauses when we get a contract or subcontract? Are there any that kind of make you perk up and want to make sure the client is aware from an accounting perspective what they're getting into?
Yeah, I think with FAR 52.216.7, which is what triggers the incurred cost submission requirement, That's one that I typically have seen in the past where a client may go ahead and flow that down where it's not technically necessary. Of course, I think that goes to Dale's point of just getting that oversight in there and just making sure that you're reading the contract and knowing what should be passed to the subs and what should not. That one is not a huge deal, but I've seen a few who have prepared and submitted because it was required by the contract, but not necessarily, maybe they had a fixed price contract and they weren't billing any kind of rates on any cost reimbursable component of a contract, so they really didn't have anything to report, if you will, on those. So again, that's just from the accounting side looking at that. I think council can help you decide, but that's a big one that I've kind of seen people talk about. Should I flow this down or should I not?
Absolutely. That's definitely one that makes us take note, as you mentioned, because of the incurred cost submission. So Dale mentioned it a minute ago. One of the big things that can come up as you become a prime is dealing with certified cost or pricing data and ensuring that you're adhering to that FAR clause. A lot of times when you're a subcontractor, one, maybe the subcontract's smaller and doesn't fit in the requirement, or maybe the prime contractor is dealing for it with you through templates, getting multiple quotes, and so it doesn't come up on your radar. But what this boils down to is certifying that costs are accurate, complete, and current. And so this is, somewhat of a TINA requirement, truth in negotiations, to ensure that the government is getting a fair and reasonable price for the product they're getting. Now, the requirement for this is a contract. It used to be $750,000. Then back in 2018, it went up to $2 million for the threshold for requiring certified cost or pricing data. There are some additional exceptions for innovative technology projects or non-traditional government contracts. So there are a few different ways when this is inapplicable. But what you're really trying to do is ensure that you have all your costs accurately recorded or proposed to the government. That information is readily available, and that you try to do your best to maintain as competitive a price as possible. And so how am I trying to do that? What are some things I can do to kind of ensure that those things are happening? If you have commercial prices for any of your items, that's really going to be a trigger, basically saying if I'm charging a non-government customer for this in a commercial environment, then that should be a fair and reasonable price. Getting multiple vendor quotes is also going to help you ensure that I have a competitive, accurate, complete price. Using a consistent and equitable rate structure, across year to year, proposal to proposal, that's going to also ensure that my burden rates are applied accurately to make sure that I'm adhering to this. And then a purchasing system policy is going to help as well. So let's see. I think we've got this question a little bit too early. I think that one's my fault. Let's not launch that question yet, Cammie. Let's hold off on it. Let's go ahead and talk a little bit about a purchasing system policy. So basically, this policy is telling me that I've got a process of how I'm going to procure something. It's not necessarily just my accounting system or anything like that, but it's basically saying I'm going to go through this process in order to make a purchase or procure something. And so there are certain requirements or certain thresholds when I am required to have a purchasing system policy. If I expect my federal awards to exceed 50 million in a 12-month period, I have to put one in. There are other times when, it may just be a good idea. Sometimes there's a contractual requirement is mentioned. We've seen cases where a solicitation, part of the evaluation criteria would be a purchasing system policy in place. And so having that in place may grade me better on my proposal and have me a better win chance on it. There can also be, if I have an approved purchasing system policy, I may be able to enter subcontract agreements without having consent action from contracting officers or anyone else. So that can also be a bonus there as well. But the objective kind of behind what the government's purpose behind this is they're trying to make sure that, there's efficiency and effectiveness as the contractor spends these funds. They recognize that some of this work has to be done either through subcontracted out or, through material acquisitions as well would also follow under this. But, the government is trying to evaluate that. If I do have a requirement, I could be required to have a contractor purchasing system review. We have a couple of FARs that cover that, 44.3 and 244, DFARs 244.3. If you are looking to implement a purchasing system to kind of help you manage these things, to manage your procurement, really the best criteria that's laid out is in DFARs 252.2447001. It kind of gives you a blueprint for it. Of course, we can also assist with these things as well. So, Michelle, you and I both do a lot of proposal pricing support to where we're helping clients come up with the pricing. And a lot of times when our clients are a subcontractor to a big prime, they're going to give them the templates. They're going to say, hey, I need you to fill this out, get it back to me, sealed bid. But if I'm the prime contractor and I'm trying to pull together, my subs pricing, I kind of have a little bit of a different set of challenges because I don't have somebody giving me those templates. Usually I've got to develop them. I've got to figure out how to pull my team together.
Yeah, that's right. I think there's a handful of times, and that's a huge shift in putting those pricing templates together and getting everything set and really thinking through what that needs to look like, having uniformity across the board so that it's easy when you receive those back in to integrate into your own pricing template, and kind of getting everything organized and structured probably is the biggest, I'll say, hurdle or learning curve there, is really understanding that piece of it, thinking through what that's going to look like, what your requirements to the subs are, the fee or pass-through burden, what's allowable and what that's going to look like, what you're going to direct the sub to do. And so there's a lot to think about when you're walking through those templates and setup. I don't think you kind of had a note on there about the mandatory type of subcontractor agreement. From my experience in working, there's not a right or wrong necessarily. I think it's really a case by case and who that sub is, what they bring to the table, how you're pricing the prime contract, and just understanding if it's a fixed price that you're asking from them versus a cost plus. A lot of the people, we've been through the subcontracting world, so we kind of understand what that means to them. And so you can understand the risk reward there and how that factors into the bid that you're putting together.
Yeah, I guess I would agree with you that I don't know of a requirement that a subcontract has to be in the same format as the prime contract, but it seems to help if everyone's on the same side of the table and kind of, trying to achieve the same objectives, whether that be firm fixed price or cost reimbursable. And that's basically sharing the risk, or at least having the risk with the contractor, having the contract structures the same. Dale, when you guys are issuing or helping clients come up with subcontract agreements, does that go into your thought process when you're creating those agreements?
Yeah, so a couple things we look at is, one is, what are we buying? So if it's, even if we're doing, cost plus work on a prime contract, if what the subcontractor is providing is a commercial item or a commercial service, then we would definitely do a firm fixed price contract under commercial terms. And beyond that, we look at risk allocation and what makes the most sense for that particular work. If we can do firm fixed price, from a price perspective, from a risk perspective, that's what we would want to do. But sometimes it makes sense just to have everybody on the same page too. So.
Agreed. So, as the participants on the call look to make that jump into the prime contractor role, what kind of liability do they need to think about? As they're no longer a sub, now they are, the government's their customer and they're managing subs. What do they need to think about in those cases, Dale?
So, the biggest thing is that, a prime is responsible for their sub's performance. And so generally speaking, if a subcontractor is not going to be able to perform their part of the work, the prime contractor is the one that holds the liability with respect to the government. And so, a few things to think about there are, one, making sure that you've got a contract in place that, allows you to receive assurances from your subcontractor so you can identify problems early and work to, either correct that with the sub or find a replacement. And the other is how you think about finding subcontractors in the first place. The biggest thing is making sure that you think you've got people you can trust on the front end instead of having to worry about compliance issues on the back. But generally speaking, subcontractor non-compliance is not going to be an excuse for prime contractor default. The only exceptions to that would be, any of the provisions that show up, for example, in the excusable delays clause, like epidemic, for example, or quarantine, acts of the government, those sorts of things.
You haven't seen anything about quarantines or epidemics lately, have you? Nothing?
I may have used that clause a few times.
All right. Cammie, can we launch that fourth poll question now, please?
Sure, I just launched it. And we'll give everybody just a couple moments to vote or to answer the question.
Yeah, thank you. And so this question, as we finish up the poll, is, is your accounting software, as you do move into this prime role, is your accounting software going to be able to handle, these new requirements you may have as far as managing subcontract and those type things? So let me know once the poll's closed, Cammie.
Okay, closing the poll.
And you want to share the results?
Yes, it looks like 100% of those who answered the poll question said yes.
Okay, good. So, Michelle, we work with a lot of different softwares. A lot of them are, government contracting specific or made for government contractors, but some of them aren't. So, it sounds like most of our participants, they feel good about their software, that if they move in that prime role, if somebody is looking to make a software change, what are you usually telling them the criteria to think about?
Yeah, I think the huge thing kind of moving into that prime role is making sure that the software that you're using has a good contracts management function to it. So that can be from funding value, tracking your billing, timekeeping. A lot of systems that we work with have those requirements, but it's really interesting because sometimes when you move into that prime role, maybe it's not something you've really used in that system before, and so you may not realize that your system has that capability. So it's something that we talk with clients a lot about, where they'll say, hey, I've got some system requirements and I'm looking for a new software because I'm going after this opportunity. So really understanding what you have, how to utilize what you have and what's out there. There's a lot of good systems out there. I think, we work with a handful of them in a lot of detail, and there are some who tend to invest more money on the front end of having modules for like subcontractor management or procurement. Those can be things that can be a little more tailored. So if you really got a need for that and you need something very robust, you may actually consider moving your system over. For instance, like a Deltek or has a really robust purchasing, and they just released a subcontractor management program where some of the other softwares, or maybe you have a QuickBooks add-on that makes your system compliant. They may not have as much there for you to utilize to manage. So it can be a little bit tricky, but I think the first thing, and I'm glad everybody said yes, is just understanding what you have in your current system before you really look at making that move over.
And I think one of the big things is your purchasing system is not just your accounting software. It's also the process by which you do things, as you mentioned, as you alluded to. And it's, do I have a requirement to get so many quotes? Or, do I have another requirement to verify some other piece of information? Do I have some kind of record keeping that I must adhere to? So, making sure all that's in place. We're running a little short on time, so some of these we're just going to kind of go through a little quicker. I think the main thing on cash flow is thinking about it as you're a prime and entering into subcontract agreements. Often a provision of a subcontracting agreement will be the subcontractor is paid when the prime is paid. I think that's pretty common that we see. It's the prime contractor doesn't want to act as the bank for the subcontractor a lot of times, and so they're not going to pay while they're still waiting for their government customer to pay them. And so I think that's something we see often. And if you're a subcontractor, as several of the participants are, I think that you've probably experienced that. And so it's really a cash flow that the subcontractor needs to plan for as they're dealing with that. And then, the prime, it's usually a good idea to have it in place for them as well. On, contract closeouts, one of the big questions we get when it's time for a closeout is determining when to deobligate funds. And so a lot of times we'll get a question from the government customer that says, hey, there's X number of dollars left on this contract. I plan to deobligate it. What we do at that point is we want to make sure all the invoices are in for the sub. So we need to be in constant contact with them, making sure if they have any potential adjusting invoices that may be coming out, then we want to make sure we have those, because what we don't want to do is deobligate our funds with the government, and all of a sudden the subcontractor 9 months down the road sends us an adjusting invoice to true up their rates. Michelle, we've certainly seen those instances and run those calculations before. Is there anything to add to that?
Yeah, the only thing I'd add there, I think that's helpful, is having them kind of do a similar contract closeout form with you as the prime, and getting them to sign off that they've validated that they've invoiced everything over to you. They've got all their final invoices, and doing some reconciliation can help the process when you are closing out the contract with the government, and give you some additional support that you can retain for audits later down the road.
Dale, is there any documentation or anything from a legal standpoint that you guys think about on contract closeouts to ensure that your clients don't have any issues down the road?
Yeah, the biggest thing is the assignment and release of claims that the prime is required to submit to the government for final closeout. You're going to have a similar document with the subcontractors just to make sure that everything is done on that side of the ledger as well. So just having that final assignment and release of claims.
All right. We went over by a little bit. Apologize for that, but I think we had a lot of great information. We got the one question in the chat. Please feel free to reach out with any additional questions. If you are interested in the CPE certificate, getting your hour credit for this, then if you wouldn't mind dropping your name in the chat box as well, and Cammie Miner will help you with that, get that taken care of. We do have one more seminar or webinar coming up in our guest speaker series, the ins and outs of leases during COVID. That'll be a week from tomorrow at the same time. Dale, we certainly appreciate your time. I know you're very busy, and we certainly appreciate our relationship with Maynard, everything you guys help us with, and all your insight today. Michelle, thank you very much for sharing your experience with clients and your knowledge on these topics as well. And we hope to see everyone at our next webinar. We thank everyone for participating.
Thanks, Brandon.